Hi, I am. My name is Sam. I am the creator of All Rise Legal Network, and this is a segment that I'm going to be calling All Rise Legal Corner with me. Um, so I will just be commenting on court dockets, different things. I'm sure you guys have all seen everyone, all the things, all the guys that I'm a super fan of. Law Talk with Mike, um, Time Served, Megs, all of them, and yeah, so we're just gonna watch this quick little um, plea hearing. The judge refuses the plea, and it's pretty good. Let's check it out. I'm working out the kinks still, obviously. Here we go.
And is want to say regarding the pre-sentence report. I know that it was just submitted um, about a week ago, but any updates that you have for me regarding this case?
Your Honor, I have nothing additional beyond what was contained in the present investigation. Thank you.
Thank All right, I'd like to thank everybody for being here and for the folks that spoke on behalf of the family here in this case. As I said when I started talking to you today, that I am a district court judge here in Hennepin County. The reason that I repeat that is because I want you to know what that means. What that means is being a district court judge in Hennepin County and in any county, as that I'm not a rubber stamp for any negotiation between any parties, nor am I a hammer to bluntly mete out justice on behalf
It's a
of
little low.
any family, any victims, any community outrage that there may be. It is my job to objectively apply the facts of any given case to the law that I am presented with, and make a decision based on the law and the facts that are here in front of me. There's been a lot said today about the evidence that has been reviewed by probation, by the courts, by everyone else as we go through this process. I can assure you that my review of the evidence included the appellate record, treatment records, pre-sentence report, complaint, statements from individuals, emails, transcripts of statements made by Mr. Braveheart, Mr. Osman, Mr. Braveheart's mother in the juvenile proceedings, expert reports written by Dr. Garrity, both for the juvenile case and a subsequent one that was done for this case. Also, the treatment summaries in this case, the memos that were written by the parties, and various studies, some of which I'm already familiar with, relating to brain development. For those of you who don't know me and didn't take 5 seconds to Google me before these proceedings began,
He must have had
I
some
don't like to spend
backlash.
a lot of time talking at these.
Yeah, I'm guessing he said that because he must have had some backlash from people saying that who is he to say if the kid needs treatment or has bad brain development? Who is he to go against the experts? Well, we're about to find out. You're about to find out right now.
Sentencing hearings, but this one certainly requires more detail and more information. So prior to becoming a lawyer, I was a probation officer for 10 years. And what that means is that I spent a lot of time reviewing the same kind of documents that are presented in this case, supervising individuals in the community who have been placed on probation, writing pre-sentence reports myself. My career as a lawyer included representing the State Department of Human Services in the mental health facilities, which also involved reviewing treatment summaries, staff reports, discharge summaries, treatment records.
He's a
Before I
smart
was
dude.
appointed as a judge,
Smart.
I was a prosecutor in the Hennepin County Attorney's Office in the Adult Prosecution Division, dealing with cases like this. I don't tell you that because I want to make this case about me. I tell you that because I want you to understand that when I review cases, I bring all of that with me, which includes the knowledge of what information is contained in these reports and how important it is to read the entire reports and all the documents that are included. It also means that over the years, I have already been exposed to a number of the theories regarding brain development and how it affects juveniles as well as adults who are in the criminal justice system. I will tell you that our system favors negotiations. There is no way that we could do all the work that we do in Hennepin County or anywhere else in this court system without negotiated sentences. We need negotiated sentences.
Absolutely, because the guilty are guilty, and if you're guilty, just take the best deal they have to offer. Why wouldn't you? Those lawyers are overworked. The public defenders are overworked. The prosecutors are overworked. The judges' dockets. I watched some dockets in Fulton County where dudes are in there for over 300 days, over 400 days without indictment in jail. Without indictment. I don't know how they do that legally, but the courts are super full. Like, it's nuts. So yeah, plea agreements are a must to negotiate deals, but the judge doesn't like this one. I don't think the family likes it. I think a lot of people retaliated or created an uproar. I don't think they went as far as to started an angry mob or anything, but they definitely let him know.
For the system to work. And I know we've all, lawyers, judges, have sometimes had to hold our nose at some of the negotiations that we've had for the benefit of the system to get things moving. But those negotiations also follow the law. In this case, as you've heard, the negotiation that is being proposed, the presumptive sentence here is a 261-month commitment to the Commissioner of Corrections. The negotiation would call for, rather than that sentence be served in custody, that the defendant be placed on probation for a period of 5 years, with that time, as we say, hanging over his head as incentive for him to follow through with any treatment that we want him to do. As most of you know, that sentence that is proposed in the negotiation and has been discussed here today is and would be a dispositional departure. In order for me to depart, I need to find substantial and compelling reasons to do that. That's why the case is here in front of me and not simply there being a plea and sentencing to the sentence that is recommended by the guidelines. The parties have submitted their negotiation and based the grounds for their departure on primarily three things. One, the defendant's lesser role in this offense. the extensive rehabilitation interventions that he's had in the time that he has been in custody, and the fact that the defendant is amenable to probation. Those are the arguments that I need to review in order to determine whether or not there are substantial and compelling reasons for departure in this case. In reviewing the record that is before me that I have already discussed, I cannot find that there are substantial and compelling reasons to depart. First, I do not believe that the record supports the party's assertions that the defendant had a significantly lesser role in this offense. People have discussed some of this already. However, I feel that as part of the record that I need to make, I need to discuss some of this further. Although the defendant ultimately did confess to the crime, it is not the case that the defendant has always cooperated with law enforcement. A review of the transcript of his statement would indicate that, although I don't know what period of time it was, that when the defendant was initially confronted with this offense, that he blamed all the offense on Mr. Osman, that he denied wanting to participate, that he even
He's gonna
denied
have a hard time.
shooting a gun, and in fact said that he was walking away when he heard the gunshot happen. It wasn't until later in the investigation and in speaking with the investigators that he finally admitted to his role in the offense, and that is that it was a joint decision to commit a robbery that day, and it was a joint decision once they saw Mr. Markey to approach the vehicle, guns drawn, bandanas pulled up, to engage in this behavior. Although it may be true that Mr. Osman's gunshot was the final one that killed Mr. Markey in this case, both the evidence and Mr. Braveheart's comments were that he also shot at the vehicle as it was leaving the scene.
That's a great
The
name.
defendant also left the scene with his co-defendant. They retrieved the backpack that Mr. Braveheart admits belonged to him. Mr. Braveheart admitted that the guns that were used belonged to him. They fled the scene. They committed additional offenses, some of which were offenses.
So yeah, they were his guns. I think he drove the car, took the car back, and he's trying to say that like it wasn't his idea, it wasn't his role. Yeah, that's one of the reasons why the judge hates this.
Where the co-defendant remained in the vehicle or acted as the lookout when Mr. Braveheart committed the offenses. He fled with his co-defendant in the vehicle until they were subsequently apprehended. At no time during the course of what was going on this day did Mr. Braveheart either abandon the crime spree or abandon his co-defendant. The parties in this case and the experts and some of the other information contained in the reports opine that Mr. Braveheart's only reason for committing these particular offenses was to gain money
For food.
to purchase food because of the situation that he was in. However, the record also indicates that Mr. Braveheart told law enforcement that he purchased the guns for about $250. What else?
Yeah, so to try to gain sympathy. I mean, it's obvious. You don't need me to tell you guys that, but to try to gain sympathy, oh, I needed food, so I committed this robbery. Well, you can go steal food, go get in trouble for stealing food, and not carjacking some fool and shooting him and committing murder. It doesn't weigh out. It doesn't weigh. The crime is too severe and too violent to be just for food. No, it's probably money for drugs or whatever to live up to this gangster lifestyle that's probably fake as hell.
Also note that none of the offenses that I'm aware of that he's been charged with and that bring us here today involved any actual attempts to steal food or anything that would help him in that endeavor. The parties also place a great deal of significance on the fact that the co-defendant fired the fatal shot. As we discussed, while it's true that the defendant did not fire the fatal shot, it is also true that the defendant fired at the vehicle as it was leaving the area. Given the time of day that this occurred, that action, in the court's opinion, made this offense more serious than maybe other carjackings, given that the defendant shot. It was approximately 5:00 p.m. in the city of Minneapolis. That was more of a danger to the general public than perhaps other offenses where a gun was wielded and the person gave up the vehicle. From my read of the reports that have been submitted, the expert reports and the arguments, it appears to me that the parties are both asking me to consider that Mr. Braveheart, because of his development, is both too young to the point that he makes impulsive decisions, that he has no control, and that he follows under other individuals, while at the same time asking me to give him credit for making what appears to be, in his mind, an extremely rational decision to only fire at the vehicle to disable it or whatever it is that he claims. The two of those can't exist in the same space.
I know
As was,
exactly. I'm
as
trying to
far as his age goes, in terms of being a mitigating factor, this was said by one of the family members as well, that not everyone who's had a similar background as Mr. Braveheart resorts to the level of violence involved in this offense and other actions that occurred on that particular day. I would also note that the record does not support a departure on the grounds of his extensive programming. I don't want to rehash everything that already went up to the Supreme Court and was part of the juvenile proceedings, except to note how it might inform my view on whether or not I consider that he is particularly amenable to probation based on his involvement in the treatment that he's engaged in the last, I think as defense says, and I think in the state's memo, 4.5 or 4 years since he has been in custody. From what I can glean, it does indicate that it was Mr. Braveheart's decision to engage in the treatment that he is engaged in. I would note that one of the comments from his treatment provider indicates that Mr. Braveheart did opine, at least at one point, that he was thinking about the positive outcome that his completion of these programs could have on his case. What my consideration on
which is the wrong reason to do the treatment. And the judge sees that, and he knows that everyone else sees it too. So for him to be bragging like, yeah, I'm going to do this so, it looks good on my case and it got back to the judge that he had said that. Yeah, not good for him.
whether or not he's particularly amenable to probation is not just about what Mr. Braveheart needs, but what Mr. Braveheart is willing to do. In reviewing the discharge summaries in this case, as well as the factual basis for some of the discharge summaries, I would note, as frankly, as the state had previously argued, that one arguably positive experience in treatment or in programming does not necessarily outweigh a lengthy history of program failures. Mr. Braveheart did agree to go to Red Wing while he was in custody, and he is to be applauded for the efforts that he made there, as well as getting his GED and being involved in both places in individualized treatment and the trauma-informed treatment. But rather than what has been described here as him wholly embracing treatment, being deeply and meaningfully engaged in treatment, fully availing himself of the treatment that was provided, the records note progress that was punctuated by outbursts, disrespect to staff and other residents, episodes of physical violence, harassment to staff and other residents. In fact, the records indicate that his discharge and transfer to West Central were delayed from Red Wing based on actions that occurred before he left the facility that would delay his entry into West Central. As far as his involvement with West Central, he went to West Central in November of 2021. The discharge summary from West Central indicates that in January of 2022, there were at least 3 major infractions that occurred, including threats to staff, fighting with another peer, stomping on a staff member's foot, and attempting to trick a resident and then stating that nothing happened when confronted about this, even though this was observed on security cameras by other staff members. It appears from the discharge summary that at least the last part of his stay at West Central were without any major incidents that they were concerned about. However, if we take that to be true, then what I'm looking at and what I'm considering to determine whether is particularly amenable to probation is not a 4 to 4.5 period of a track record of solid treatment. It's a 4-month period where he has only had what may be described as minor infractions. What I need to determine is not whether he is amenable to probation and whether he needs treatment, but whether he is particularly amenable to probation. And that is that it's above and beyond what the average person who might be placed on, or that we might be considering,
which means a higher
for
standard.
a departure here.
Which means a higher standard.
with the record that I have in
then
front of me,
you or I would
based on
have to be.
the findings of the treatment officials, his involvement in this particular offense on that particular day, and the actions that were taken by Mr. Braveheart on that day, I cannot find that he is particularly amenable to probation. And therefore, based on my review of the record, I am not accepting Mr. Braveheart's guilty plea at this time. With that, Ms. Bailey, how would you like to proceed?
Trial.
Thank you, Billy.
Yeah.
Next step that's available at this point is
Well,
another omnibus.
there you have it. Yeah. So they'll probably go to trial, try to renegotiate, maybe renegotiate the plea deal, like have some sentencing, differences, definitely not just probation. He'll probably have to go to prison. There's no way that judge is going to let him do just probation or an intensive probation. So yeah, so there it is, man. I think it's just fascinating. The judge knew he needed to explain his situation for the Court of Appeals when it does get sent to the Court of Appeals. It takes a lot for a judge to depart from a plea deal because of the need, like he explained, of the for plea deals and negotiations to happen to kind of clear up the docket. But this is definitely a more severe matter. He couldn't let it go, and good for him. Good for him. All right. Well, that's all I got. Still working out the kinks of my streaming. I'm going to get an intro, some music, some other things, some like little goofy GIFs or whatever, to try to create some good original content. I know a lot of people are doing LawTube. I'm doing LawTube because of how much I enjoy LawTube. I just don't want to be an observer anymore. I want to participate and not just in a chat. So awesome. I will see you guys again soon.